Good afternoon, Your Honor.
Awesome. Thank you. Okay. All right. And now we have somebody here for everybody as well. So let me cross-check Mike's off my list. Okay. Ms. Love, was there any evidence you wanted to present or any witness you wanted to call with regard to our morning proceedings?
Your Honor, given the scope of what the court has already told us that we were looking into, I don't have any witnesses based on Ms. Bumpus's testimony. And my understanding is that it was Brady material disclosed during the June 10th, 2024 hearing in chambers.
Correct. And what she alleges was disclosed is that Mr. Copeland said, I know more about the Infinity, and it has to do with somebody that's not on trial. I'm paraphrasing, but.
And so the fact that.
Hang on a second.
Yes, ma'am.
Yes, sir, Mr. Weinstein, you think there's more to it?
I didn't mean to give you side eye, Your Honor. Yeah, I do believe that there was more that she said that was disclosed other than just the Infinity.
Okay, what else?
Specifically when she said that the state would not prosecute Mr. Copeland for lying except for that one thing, which she said was the murder of Donovan Thomas. I believe that was on the redirect at the very end. With that,
Yeah.
That actually came through more clearly than I think anything else, Your Honor.
Okay,
Yeah.
so.
May I respond to that? So because that did not, in my mind, amount to Brady, if the court is inquiring into a different issue of.
Hang on just a second. Everybody who's got a phone on you, make sure it is on silent, and you should only have a phone on you if you are an attorney or if you have a Rule 22 that permits you to have a phone. Anybody else in here should not have a phone on them at all. If you do, it should be turned completely off.
I'm sorry, Your Honor, that was my computer.
Okay, it happened. Oh, your
silenced
computer?
it.
Okay.
I silenced it.
All right, thank you. So, Ms. Love.
I was just saying that based on the parameters that the court set forth, my understanding was that anything that is alleged to have been said by Ms. Hilton in that regard does not impact whether or not Brady material was disclosed. And I'd have a different argument at the appropriate time that the court tells me is the right time to make it. But my position would be that given that defense attorneys came to Ms. Bumpus within an hour of the meeting before court went back in session and asked her, so they had information, they had, I assume, the content of whatever it is that they are alleging took place. And then Ms. Bumpus, based on what I heard her say, told them, sort of filled in the blanks, I'm using my words, not hers, and gave to them this information. My understanding of what Brady is that it is information that is not available to them by any other reasonable means. And they have, obviously, they had someone telling them something about what was going on. So it's not a Brady violation if they had access to it. If there's a different argument, a different issue that we're going to be arguing, I'll hear that from the court. But as to the Brady violation, my argument is that based on her testimony, there was no Brady violation.
Let me add this, Your Honor, too, if I may. Also, the testimony of Mr. in the off-the-record meeting where Mr. Copeland.
The alleged off-the-record meeting.
The alleged off-the-record meeting with Mr. Copeland, to which Ms. Bumpus testified to, where Mr. Copeland allegedly said, I can claim all of this, I can take all of this over and over again, and the all of this was regarding the unliving, the murder of Donovan Thomas. I would submit that Mr. Copeland allegedly saying, I can claim all of this, I can take all of this, would also be Brady material.
And Your Honor, again, given that Ms. Bumpus is the person testifying about it today, and that Ms. Bumpus is the person that was approached by members of the defense within an hour of the meeting. That assertion made by her, though I don't agree with counsel's characterization of it, is information that is available to them. But more importantly, Your Honor, I asked Ms. Bumpus specifically what was asked right before. What she said, she understood it to mean Donovan Thomas. But I can claim all of this. My position is that it's not Brady. I can say I can claim it all too. But a hypothetical, I can. What you can do is not saying something that is.
All right, I understand your argument. So just for clarification, you said I had set parameters as to what is and isn't Brady, and
No.
I haven't set any parameters as to what is and isn't Brady. Brady is what Brady is.
I agree. No, I'm saying the parameters that I was speaking of was that you were talking about this hearing is about whether Brady material was disclosed. And my position was that what Ms. Hilton is alleged by Ms. Bumpus to have said to Mr. Copeland would not, I don't think it would amount to Brady, but if it did, I can put up a witness about it. I just didn't think that it was necessary unless the court saw it differently than I did.
So I guess what I wanted to have us look into is whether what was alleged to have occurred, i.e. an off-the-record conversation that was between Ms. Bumpus, Mr. Copeland, and Ms. Hilton occurred, and then if so, what the substance of it was and whether it contained any Brady. So if you don't want to dispute whether it occurred, that's up to you. I'm not going to tell you how to run your case, but I think that's a part of the inquiry as well. So I don't want to mislead you about that. So if you have any evidence that you want to present to dispute whether it occurred or to give us some more, shed some more light on that subject, you're welcome to do that as well.
State calls Deputy Chief Investigator Antonio Long.
All right.
Your Honor, can I make a statement before or while Investigator Long is taking the witness stand? I am specifically objecting to the proffer of Ms. Love, always. But in addition, Ms. Love said that me and other people who represent people, God forbid, accused of these acts, knew already about the ex parte meeting and what occurred and the contents therein, and that is just false. That is just false. That was not testified to by Ms. Bumpus. What she said was they knew that a meeting occurred. No one said contents.
Actually, my recollection is that I asked her specifically that question. Did you share the off the record portions as well? And that she said, yes, she did.
I agree with that. Ms. Love said that before meeting with Ms. Bumpus, that me and other lawyers or people on the defense side knew about what was said at that hearing, and that did not happen.
That's totally irrelevant. So I appreciate it, but I wasn't even accepting that as any kind of a proffer of hers. But yes, so noted, and that's fine. Okay, was there anything else with regard to that? All right. So you said you weren't going to accept a proffer from Miss Love, and that's fine. You said also Miss Long. Do you mean Investigator Long or Miss Hilton, or is there a Miss Long?
Miss Love is who I meant, but I think because Investigator Long has taken the stand, my mind may have been been with him.
Okay. And with regard to just on that topic, the earlier proffer by Miss Love that you objected to, and you said on the record, I don't ever accept any proffer from her. And I said that's up to the court. I meant it's up to the court whether I want to hear it or not. But with regard to that, and that was about Mr. Abate, my ruling with regard to that was that's not even relevant. If until such point as there might be some other defense motion filed, at which point Ms. Love can call Mr. Abate. So, okay, so call Investigator Long. Thank you.
Raise your hand. You swear for testimony you give the truth, the whole truth, and nothing but the truth. First and last question. Antonio Long, Antonio, last name Long, Long.
And Your Honor, before I begin, I just wanted to point out that I'd like to just make the record. I know that everyone may be familiar with Deputy Chief Long, but I'd like to ask the preliminary questions that establish who he is and where he works, with the court's permission.
Okay, that's fine, but he's going to be testifying as an expert, so let's just, cut to the chase. To the extent he's not going to be testifying as an expert right now. He's going to be a fact witness.
Yes.
Okay.
Yes.
So we don't need to go through all of his background. All right.
Just good afternoon, Deputy Chief Long. Would you tell the court for the record where it is that you work?
I work for the Fulton County District Attorney's Office.
In what capacity?
Deputy Chief Investigator.
As Deputy Chief Investigator, are you over any particular units?
I am.
All right. Are you over the unit that is prosecuting this case that we are here in trial on?
I am.
And as part of your responsibilities as Deputy Chief Investigator, do you accompany attorneys to meetings with witnesses or other attorneys?
Yes, I do.
Specifically, are you tasked with accompanying Deputy District Attorney Hilton and myself when the needs arise?
And among other attorneys, yes.
On June the 10th, 2024, do you recall that date?
I do.
And did you accompany myself or Ms. Hilton to the chambers of Chief Judge Glanville on that day?
I was with Ms. Hilton.
Was there anyone accompanying me? As
Yes.
And was that person one of the lieutenants with the DA's office?
That is correct.
While as Deputy Chief Investigator, do you give instruction to lieutenants and investigators regarding how they are to keep the lawyers in line and keep their eyes on the lawyers?
Yes, I do. I give guidance and counsel in reference to that.
And are you all required to remain with us at all times during those types of meetings?
Yes.
June 10th of 2024, do you recall who was present in the judge's chambers at the time you arrived with Ms. Hilton?
I do recall Judge being present, court reporter, Ms. Kayla Bumpus, several deputies, and with Kendra Copeland, and myself and Ms. Hilton.
Was I present in chambers at the time you arrived with Ms. Hilton?
Not when Copeland was there, no.
Did I ever come back after Copeland arrived in chambers?
You did not.
Did you remain with Ms. Hilton during the entire time that she remained in chambers?
I remained with her the entire time she was with Ms. Copeland.
Okay. Were you present with Ms. Hilton when was Ms. Bumpus in the room during the entire time that Ms. Hilton was in a room with Mr. Copeland?
Yes.
At any time did Ms. Bumpus leave the room and leave Ms. Hilton in the room with Mr. Copeland without his attorney?
No.
Were you present in the courtroom today when Ms. Bumpus testified?
I was.
Did you hear Ms. Bumpus talk about an off-the-record conversation that took place between Ms. Bumpus, Ms. Hilton, and Mr. Copeland?
I did.
Do you recall during the time that you were in chambers with Ms. Hilton, how many times, if any, that you all went off the record?
Make sure I understand your question. How many times do we go off the record?
Yes, and let me back up and ask you this. Were you able to discern when you all were off the record?
Yes.
How?
When the court reporter was not documenting what was being taking place.
Was there ever a time that you all went off the record at either attorney's request, that is either Ms. Bumpus or Ms. Hilton's?
From what I recall, there were times we stepped out of the room so that Ms. Kayla could talk to Mr. Copeland. And then the last time, there was a conversation before we went back on the record.
At any time that you all stepped out of the room so that Ms. Bumpus could speak with Mr. Copeland, did you observe me go into that room?
No.
Now, when you said there was a conversation that took place the last time, would you please tell the court what you're referring to?
The conversation I believe Ms. Bumpus is talking about right before we went back on the record. There was a conversation where Ms. Hilton spoke with Ms. Bumpus and Copeland before the judge and the court reporter went back on the record.
Did that conversation take place following a time when Ms. Hilton exited the room so that Ms. Bumpus could speak to Mr. Copeland? Or was that a time when you all were sitting in the room and you just went off the record?
That was a time where we took a break, and before we came back on break, it happened. If I'm answering your question, if I understand your question.
Did you all, you being you and Ms. Hilton, did you all leave the room when you say you took a break?
Yes, everybody left the room.
Okay.
Except for Mr. Copeland and the deputies.
Okay. Did Ms. Hilton have any contact with Mr. Copeland during the time that Ms. Bumpus was not in the room?
No.
Were you present when, or do you have any memory of Mr. Copeland saying something akin to, I can claim all of this?
No.
Were you and Ms. Hilton within close proximity, within 2 feet of each other during the entire time that you all were in chambers?
Yes.
Are you able to say whether you all would have been privy to whatever was said? If she heard it, you would have heard it. If you heard it, she would have heard it.
Correct.
Do you recall speaking with Ms. Bumpus and Mr. Copeland about the Donovan Thomas murder?
No.
Generally speaking, starting there, would you tell the court what you recall talking about?
I'm unclear as to when you're talking about. Starting where?
During the time that you were in chambers with Ms. Bumpus, Mr. Copeland, and Ms. Hilton, can you tell the court the topics that you discussed, that not you, but Ms. Hilton and Ms. Bumpus and Mr. Copeland discussed?
The topic at that time, Ms. Hilton just made it clear to Mr. Copeland, she expected him to tell the truth, and that if he was going to get on the stand and claim something that he know he didn't do, then she would be looking at prosecuting him for perjury.
And so I'm clear, is this on the record or off the record that this conversation takes place?
This was off the record just before the judge came back in.
Have you had an opportunity to read the entire transcript of the in-chambers hearing?
I have not.
Do you recall Mr. Copeland making any direct statements about his involvement in the Donovan Thomas murder?
He never mentioned anything about involvement in Donovan Thomas murder.
Do you recall him making any indirect statements or statements that could be construed as an involvement in the Donovan Thomas murder?
No.
Did Ms. Hilton, during her conversations with Ms. Copeland while you, Ms. Bumpus, Mr. Copeland, Ms. Hilton, the court reporter, not the court reporter and the judge. In other words, during an off-the-record conversation, did Ms. Hilton...
All right, hey, back up. So, is it your testimony that there was one brief off-the-record time when Ms. Hilton, Ms. Bumpus, and Mr. Copeland were all in chambers, but before the judge was back in chambers? Or just tell me, maybe I'm yes, no?
Yes, we broke for someone used the restroom.
Okay.
And before we went back on the record, that's when Ms. Hilton and Kayla had the conversation before Ms. Weaver began to record everything.
So Ms. Weaver was sitting in there.
She was not in there at the time they were off the record.
Okay, well, I mean, you can be off the record and still have the court reporter sitting in there, so I'm just trying to get
she was not in there.
clarification. So this was after a bathroom break.
Right.
Ms. Hilton and Ms. Bumpus head back into chambers before the court reporter and the judge are back. Is that right?
Well, I want to say Ms. Weaver did come in,
Okay.
and then Ms. Hilton did ask she needed to say something with Kayla and Mr. Copeland before the judge came back on the record.
And Mr. Copeland's in there at that point in time?
Mr. Copeland was in there.
All right. And so what is the substance of that very brief 2-minute or whatever conversation?
It was Ms. Hilton explaining to Mr. Copeland that if he did get on the stand and take credit or try to take credit for something he didn't do, she would then seek prosecution for perjury.
She would
seek prosecution for perjury.
And did she talk with any specificity about what crime or crimes that would include?
She did mention the Donovan Thomas case, and that if you got and claim something that he knows he didn't do, and we have proof that he didn't do, then she would prosecute for perjury.
All right, and so your recollection is that that conversation occurred off the record before the judge was in there?
Yes.
Okay. Do you have a recollection of a very similar conversation also occurring on the record?
No.
So if it's reflected on the record, then that's the conversation that occurred?
Say that one more time, Judge.
Were there two very similar conversations about that, where Ms. Hilton is saying, if you get up and say something that we know you didn't do, we're going to prosecute you for, or we or I'm going to prosecute you for perjury?
During the course of the conversation, Mr. Copeland's concern appeared to be his statements were inconsistent statements.
I'm talking about just the off the record now.
Just off the record was just in reference to him taking responsibility for something that he didn't do.
Okay. I have no idea why that phone is ringing or how to turn it off. This is not my courtroom, so we're just going to ignore it. That phone being the desk phone on the bench for some reason. I don't know why. Okay, sorry about that interruption. All right, and you only recall one conversation about that, whether it occurred on or off the record?
I only recall one conversation specifically in reference to Ms. Hilton saying that she would seek perjury unless it was something blatant, a blatant lie.
She would or she would not?
She would not, unless it was a blatant lie. She wasn't concerned about inconsistencies that she would use impeach. She would just impeach him for inconsistencies.
Okay. So do you recall any conversation where Ms. Hilton says, and this is on or off the record, Ms. Hilton essentially says, look, if you get up there and you claim something that you're the one that did something and I flat out know you didn't do it, I'm not going to prosecute you for perjury for that because I don't know what your reasons might be.
I don't recall a conversation to that. I do know that she used an example that she would have to corroborate something before she prosecute.
Okay. All right. So the extent of the off the record before the court got back in their conversation was her essentially just saying what?
Her conversation was in reference to him getting on the stand and taking responsibility for something that he know that he didn't do, or falsely admitting to something that he did after receiving use immunity.
All right. Go ahead, Ms. Love.
Thank you, Judge. Did Ms. Hilton attempt, or did she make any effort to explain perjury beyond what you just described for the court? Do you remember her doing that?
Doing this off the record or just in general?
In general?
Yes, she did.
Was the conversation that you are relating to the court that happened off the record, did it refer to matters that you later discussed on the record as well, or not?
All of it, in a sense, was stuff that per se was explained on the record. It was just clarifying what would constitute perjury versus inconsistent statements, or whether she would need to impeach him.
And showing you, for instance, just page 50 of the transcript, line 11. I'm sorry, line 19. If you'll just take a look at it, is that an instance that is similar broadly in nature to the type of the conversation that took place off the record that you were just describing for the court? And by that, I'm talking about where Ms. Hilton is saying that's different, referring to the word purge. And Mr. Copeland says that can get me back in jail. And Ms. Hilton says yes. And Ms. Hilton in line 24 of page 50 says, it's not what you're saying. What you're saying is not perjury. What you're saying is what we call a prior inconsistent statement, and so forth and so on. Is that the type of conversation that took place off the record?
Objection, lady.
Sustained.
Yeah.
Sustained. Ask a different question.
Yes, Your Honor. During the conversation off the record, did Ms. Hilton endeavor at any time to help Mr. Copeland understand the difference between perjury and purge?
If you remember.
I don't remember if that was substance of the off the record. I do know during the course of the meeting, she repeated that several times, trying to explain the difference between purge and perjury.
And off the record, the comments that Ms. Hilton made regarding hypothetical instances where perjury could be occurring, did she clarify for Mr. Copeland in any way? Did she seek to clarify how she would be able to distinguish between perjury and something that wasn't perjury?
Objection, lady.
Overruled.
The off the record conversation was very brief and very short. And there wasn't a whole lot of explanations because that had already taken place.
Do you remember anything that Mr. Copeland said in response to what Ms. Hilton said about being able to, if he got up on the stand and admitted something that she could prove he was lying about?
Yeah, is this you asking during the off the record conversation?
Yes.
Okay.
He said he wasn't going to do that.
And what is it that he said he wasn't going to do?
Get on the stand and lie for something he didn't do.
Okay. Do you have memory of him asking or saying something about not going to say that he killed Donovan Thomas?
He didn't use that word. He said he wasn't going to take credit or say he did something he didn't do. Yeah.
do you recall that those words you just spoke were in response to a question about the murder of Dr. Thomas?
It wasn't a question specifically about Donovan Thomas. It was a question about him getting on the stand. It was a statement about him getting on the stand and taking credit for something he didn't do.
And broadly, do you recall Ms. Hilton making comments about Donovan Thomas that Mr. Copeland then made any comments about?
Other than if he got on the stand and took credit for something or said he did something that he didn't do and we knew he didn't do. That was the only statement she made, and then he said he wasn't going to get on the stand to do that.
Okay. Now, do you have any memory of Mr. Copeland, either on the record or off the record, saying anything about a gray infinity that the state, about having information about the infinity that the state doesn't know?
He never said anything about an infinity to me or Miss Hilton.
Did you ever endeavor to find out what he may have told Ms. Bumpus privately? I don't want you to reveal if you heard it. I just want you to know if you ever endeavored to find out what he may have said to her privately.
No.
And would it
Go ahead.
Would it have stood out in your mind if Copeland had made any kind of inculpatory remarks about the murder of Donovan Thomas?
Almost definitely. If he had made a remark about the murder of Donovan Thomas, then we would initiate an investigation. And I would assign one of those lieutenants to assist me with looking into that.
Do you have any memory of any exculpatory remarks Mr. Copeland made about any defendant currently on trial or not on trial regarding the Donovan Thomas murder?
No.
Your Honor, I'm
Go ahead.
ceding the floor.
That's
Okay.
fine.
All right. Does your memory of what took place during any portions of the conversation that were off the record, does your memory align with what you heard Ms. Bumpus testify about regarding off the record conversations?
The restroom break, just the restroom break.
And what about the content of the off the record conversations? Does your memory align with what her memory is as she testified about?
Not for the majority of it, no.
Would you tell the court any discrepancies between what you recall and what you heard that she recalls?
The off the record, like I said before, basically Ms. Hilton having the conversation about Mr. Copeland getting on the stand and taking credit or claiming something that he didn't do and that we know he didn't do. That was in just the gist of the off the record conversation before the judge came back in.
And what, if anything, did you hear Ms. Bumpus talk about that you have no memory of whatsoever, or that you can testify in your recollection did not happen?
The incident about the infinity, him claiming that I can claim all of this, the part about you coming back the second time, that's what stands out to me right now.
And was my absence from the interactions between Ms. Hilton and Mr. Scratch that. Your Honor, that's all the questions.
All right. Thank you. Anybody from the defense side have questions for Investigator Wong? Miss Love, do you need a cough drop? Because I actually have some if you need one. Okay.
This court.
Okay.
Investigator Long, good afternoon.
Good afternoon.
I want to talk to you specifically about the off-the-record portion of the meeting on June 10th, 2024, okay?
Okay.
All right, and if I have it mixed up, was off the record versus on the record, just correct me. I'm trying to understand myself, okay?
Yes, sir.
All right. First of all, the off-the-record portion of this ex parte meeting, you said that Ms. Weaver, the court reporter, did come in to the judge's chambers, the judge's back room and chambers during that discussion, correct?
Everybody was coming in initially.
Okay. And that was before what we're deeming the off-the-record conversation, correct? And Ms. Hilton specifically requested Ms. Weaver not to take those communications down, correct?
I wouldn't say she directed Ms. Weaver, but she did say she wanted to talk to Ms. Bumpus before we went back on the record.
She made the request, Ms.
Yes.
Hilton. Okay, and that was to remain off the record was requested by Ms. Hilton and Ms. Hilton alone.
Yes.
Can I get a little clarification there? So this is after the restroom break, right? Or whatever kind of break it was?
Yes, Judge.
Okay, and when Ms. Hilton said, I want to speak off the record to Ms. Bumpus for a minute, was Judge Glanville already in that room by then or not?
He had stepped in and then ended up stepping back out.
Okay, and so, all right.
Yeah.
Thank you.
And you indicated that during this off-the-record portion, Ms. Hilton stated to Mr. Copeland that she would not pursue perjury charges unless it was a blatant lie. That was said during the off-the-record portion, correct?
No, that's not what I testified to.
Okay, when was that stated?
I don't ever recall her saying that she wouldn't seek charges unless it was a blatant lie.
Okay.
I think she was trying to explain the difference between the inconsistent statement and then a outright lie, if I can use that terminology.
Well, what did she say?
What do you mean? What she said?
Well, you said that when I said she would not pursue perjury unless it was a blatant lie, you said that was not what she said. So what did she say regarding that?
And off the record?
Yes.
Yeah. Her statement or comment to Mr. Copeland was that if you did get on the stand and you took claim or took credit, this me paraphrasing, for something that you did, then knowing we know you didn't do it, then she would see perjury charges for that.
Okay. And you indicated, my understanding of your testimony is you indicated that at some point Ms. Hilton specifically referred to getting on the stand and claiming responsibility for the Donovan Thomas situation. Is that correct?
Yeah, if he took credit for something he didn't do, yes.
But specifically, it was stated the Donovan Thomas situation, correct?
Yes.
Okay, and that was out of Ms. Hilton's mouth?
Yes.
Okay, so Ms. Hilton specifically, during the off-the-record portion, referenced Mr. Copeland taking credit or taking responsibility for the killing of Donovan Thomas.
Yeah, it didn't come exactly like that, but yes, it just yes.
And Ms. Hilton specifically said that if Mr. Copeland did that, she would seek perjury charges against Mr. Copeland, correct?
If he got up and he took credit for something he knew and he didn't do, yes.
Well, you keep going back to you didn't do, but in the fact is in that off-the-record portion of the conversation, it wasn't just generally something we know you didn't do. She specifically said
It was both.
killing. Okay, so it was specifically something we know you didn't do, and then she also said specifically
Right.
for claim responsibility killing of Donovan Thomas. Okay, so to your recollection, if you recall, prior to Ms. Hilton, did Ms. Hilton just bring Donovan Thomas that case into the discussion, or did Mr. Copeland say something that Ms. Hilton was responding to when she warned him not to take credit for the Donovan Thomas killing?
Ask the question one more time.
What did Mr. Copeland say before then that prompted Ms. Hilton to start talking about Donovan Thomas's murder?
Mr. Copeland didn't say anything. I can only, I believe Ms. Hilton was attempting to just explain because he had received use immunity, not to go in and try to claim something that he didn't do because he received use immunity.
So your testimony is Mr. Copeland didn't bring up Donovan Thomas, but Ms. Hilton brought up Donovan Thomas murder.
Right.
Did Ms. Bumpus bring up the Donovan Thomas murder prior to that?
Not that I recall, no.
And how was it determined when Ms. Weaver was going to start making a record of this meeting again?
I don't know how it was determined.
Did someone call her in? Did someone ask her to start recording now or taking minutes now?
Yeah, I believe if you're asking what made her prompted to,
Yes.
yeah, we said, I don't recall if it was Ms. Hilton, but Ms. Hilton may have said we're finished talking, and we called everybody back in.
And instructed the meeting to go back on the record? Instructed that the meeting should go back
I
on
don't
the
know if we
record?
instructed, but we were clear to go back on the record.
I have no further questions. Thank you.
Thank you.
Anybody else?
How are you, sir?
How you doing, Mr. Steele?
I'm okay. How you doing?
I'm doing fine. Blessed and highly favored.
Can I ask you a couple of questions?
Yes.
What was your understanding, if you had one, of why you were having this ex parte meeting?
Objection, relevance.
Sustained.
At what point were you initially told that you're going to this ex parte meeting?
Objection, relevance.
I want to know which part he was there for. The beginning part, he said he came with Miss Hilton. I want to clarify.
Ask your question again.
At what point did you become aware that you're going to this ex parte meeting?
I'll allow that.
I believe that morning.
And when you say that morning, was it before the meeting began? Do you know when the meeting began?
It was before.
Okay.
It was before the meeting.
And who alerted you that?
Ms. Hilton, I believe. Yeah. Because of course we had to escort him over to the judge's chambers.
And did you escort, when you say them, who did you escort to the center? Say one more time.
Ms. Hilton.
And was Adrian Love already there in the meeting, or did she come with you or go after you?
She was already there.
All right. Now, how often, besides this day, have you had these type of meetings with Judge Glanville?
With me, just this one.
How about with other people that you know about?
With Judge Glanville, no. Never happened with Judge Glanville.
Well, in this case.
Just this one.
Okay. All right. Thank you. Thank you.
You're welcome. Anybody else from the defense?
Oh, I have one other question.
Go ahead.
Did anybody tell you that that was not to be told to other people who are not invited to that meeting?
Objection, relevance.
What's the relevance of that?
The state of Georgia, I objected to it, made a statement that I somehow knew about this beforehand, which is not true. So I want to ask if anybody directed anybody to tell somebody from the defense, not tell anybody from the defense.
I'll allow it.
Your Honor, I never I did not represent to the court.
That's fine. It's all right. I'm going to allow the question.
No. If I understand you correctly, did anyone tell me not to say anything?
One more time, you spoke very fast.
I'm sorry. Was your question, did anyone tell me not to say anything about this meeting?
Yeah.
No.
Did you tell anybody about the meeting? Did you personally tell anybody, me, any of the other defense lawyers, any of the people accused of this meeting?
No.
Thank you, Your Honor.
Mr. Matthews? While Mr. Matthews is making his way over, what is your recollection as to sort of when during the meeting, like within the first 10 minutes, within the last 10 minutes, right in the middle, if you recall, that the bathroom break and then short off the record conversation occurred that you testified to?
This was near the end.
Near the end?
Near
Okay.
the end.
All right.
Good afternoon. How are you today?
Mr. Mathis, how you doing?
Doing well, thank you. Just a couple of questions. Did you have any recording devices in the meeting yourself?
No.
Did you make any written notes of any of the meeting yourself?
No.
Okay. And just for the record for today, you were actually in the courtroom during the time that Kayla Bumpus was testifying before this honorable court, correct?
That's correct.
Okay. Did you know this morning before court that you might be testifying about this matter today?
I did not know.
Okay.
I could ponder, but I did not know.
Okay. All right. That's all I have. Thank you.
All right. Anybody else? Any redirect?
When you spoke about the comment that Ms. Hilton made about claiming something that he didn't do, or the Donovan Thomas murder, did she qualify her comments in any way?
What do you mean by qualify?
Did I hear, did she tack on anything about if she could or couldn't prove it? Or did she just say, if you do this, I will charge you with perjury?
She consistently, if she's mentioned charge, she would say that she would have to corroborate anything for we charge. But she did mention the fact of I can only speculate, I would use the word, the concern about him trying to take claim for something after receiving free use immunity.
And were those comments that she made that you're talking about also accompanied by any kind of explanation, like if I can prove it, or?
Yeah, because she mentioned the fact of if we knew, and we know you didn't do it. Yeah.
Thank you.
Mm-hmm.
Thank you.
Anything else from the defense? All right. Is the transcript before the witness at this point? I don't know where it went to.
Yes, Your Honor.
Okay. Can you flip to page 41 and take a look at, well, the end of 40, starting at line 20, and then review that through the rest of line, or the rest of page 41? Let me know when you're done.
Okay. I'm done, Your Honor.
All right. Is it a fair characterization that during that portion of the meeting, Ms. Hilton, Ms. Bumpus, and Mr. Copeland are talking about what might or might not get him charged with perjury or false statements?
Yes.
And does Mr. Copeland raise the issue of murder and whether it has a statute of limitations?
Yes.
Okay. And does Ms. Hilton at some point after that talk about if she knows that he's lying about something and there's no other evidence, what that might or might not result in?
Yes.
All right. Do you recall whether the off-the-record post-bathroom break conversation occurred before or after this on-the-record conversation?
Give me just a second. Let me look a little past just to make sure.
Sure.
It happened after.
Okay. If you take a look at the entire rest of the transcript, do you think you might be able to figure out about when that break and off-the-record conversation happened?
I will take a look.
And I mean, you may or may not be able to, but if you can, let me know. If you can't, let me know that as well.
Your Honor, I believe page 52.
Can you find out whether that's somebody who has a Rule 22? And if it is not, they cannot come back in with that phone. Thank you. Go ahead. I'm sorry.
No problem. Your Honor, I believe 52, around 13, 14,
Okay.
when we come back in. Let's see. Yeah, I think somewhere around in there.
Okay. And a break is actually indicated at lines 9 through 13 or so. Is that right? Okay.
Right.
And then at line 14, the court remarks, Mr. Clopin, have you had an opportunity to talk with Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any other questions?
Yeah, 'cause
so
that
it's
was near
right
the
before
end.
that the off-the-record conversation occurred? Okay, thank you. All right. Any other questions by any counsel? Defense counsel? All right. Anybody else? Silence equals none. Okay. Ms. Love, anything?
Yes, Your Honor, thank you. Deputy Chief Long, on page 40, lines 20 through 25, when the court refers to comments made to Mr. Copeland earlier by Ms. Love. Did you ever hear those types of comments made by Ms. Hilton?
Yeah, Ms. Hilton. Yeah.
Was there any time you are aware of that Chief Deputy Love, myself, would have been in a position to make those comments to Mr. Copeland that morning?
No, not with Copeland in the room. You weren't around at all.
Okay. Thank you, Judge.
Okay. All right, investigator, thank you. You may step down. Any other evidence, Ms. Love?
Not about, no, Your Honor, not at this time.
All right, any rebuttal evidence from anybody on the defense side of the room? Actually means.
So, Your Honor, there's a case that I believe that Mr. Steele has shared with you. I'm trying to get the site right now. Ford Motor Company versus Young, 322 Georgia Appeals 348. And that case deals, that case, when we've been discussing this in the past, there's been suggestions that if there was judicial misconduct or what we believe is judicial misconduct from this side of the room, or if there was prosecutorial misconduct or what we perceive to be prosecutorial misconduct from this side of the room, that the remedy was with the bar. And that case, the Ford case, indicates to me that Your Honor and the trial court can play an active role in fashioning remedies in the case of judicial misconduct and or prosecutorial misconduct.
I don't know about judicial misconduct. That's not what that case stands for.
Prosecutorial misconduct, or lawyer misconduct, I should say.
Violations of the state bar rules.
Yes, and can I go get one thing for myself?
Sure.
So I filed a motion on Friday.
Yes, I worked diligently over the weekend on writing an order with regard to that motion. Haven't gotten to the Brady portion of it yet.
So, and I appreciate that, Your Honor. I appreciate the attention that you've given it. That motion in the beginning lays out things that I've observed, that I've felt have been highly irregular about this case. The point of my inclusion of that in my motion was not to draw extra attention to it or for anyone to feel sorry for me or anything else, because it's really about my client, Mr. Stillwell. But the purpose of it was to try to inform the court at least from my perspective, and I think the perspective of some of my colleagues, that things have been irregular in this case, and that there are real life consequences and consequences to the trial when we perceive what we believe is the lack of an impartial trial judge and also of prosecutorial misconduct. In this case, from my perspective, we've had, with the ex parte communications in themselves, I don't believe that there was a valid reason to initiate the meetings. I believe that the state and members of the state's prosecution team in particular took something very small and jumped to unbelievable conclusions as a way to get their foot in the door of the judge's chambers to have a discussion. And there were at least 2 discussions that took place. I'm assuming that there was a third discussion which may have strictly involved the grant of immunity.
All right.
But, right.
I think we cleared that up on Friday because we specifically asked, was there any hearing or any kind of ex parte anything with regard to getting the order, or was it just the motion being filed? So, right. I mean, I don't have any reason to believe there's yet another one, but.
Right. And you know, there's a potential under the King case that one, if it was just for the purposes of granting immunity, may have been a proper ex parte, but these were not. The substance of these meetings exceeded what is appropriate. They violated Uniform Superior Court Rule 4.1, which says that judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Georgia Code of Judicial Conduct Rule 2.9 prohibits ex parte meetings except for a narrow exception: scheduling administrative purposes or emergencies that do not deal with substantive matters or issues on the merits. Provided that, so we don't believe that it falls under an exception to begin with, provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. In my view, the transcript reveals open discussions about, you're going to testify, you can say you don't recall. They're basically walking through the procedures for laying the foundation for prior inconsistent statements. To say that doesn't put that meeting with just the judge and the witness who has been sworn in doesn't put the state at a tactical advantage over the defense who's excluded, I don't believe that to be the case. Secondly, even if it falls under the exception, the judge must make provision to promptly notify and give the parties the substance of the ex parte communication and an opportunity to respond. We were not promptly notified. We found out through, I keep saying, doggedness and happenstance. I believe that's what it was. We learned about it, and then when we asked for an opportunity to respond, we were promptly greeted with an invitation to go to the jail for 20 days. So that was violated. The Georgia Rule Professional Responsibility Rule 4.2 regarding communications with a person represented by counsel. The state, it's the worst kept secret in this courtroom that John Melnick represents Kenneth Copeland. Worst kept secret. Everyone knew that. I knew that, and that's why I called Mr. Melnick.
Okay.
The state is somehow claiming that in this case where the world is watching, it's a huge case, that they did not know that Mr. Melnick was representing Kenneth Copeland, and they went behind Mr. Melnick's back and initiated conversations with Mr. Copeland. Let's be frank, all these gentlemen are facing RICO charges with overt acts going back to 2013. So this is not a case where Mr. Copeland could not possibly be prosecuted. He could easily be indicted. He could easily be indicted and put with the rest of the gentlemen who were severed off of this case and be in Rice Street right now. He was in legal jeopardy when the state was seeking to speak to him outside the presence of his attorney. From our perspective, that was a knowing violation of Georgia Rule of Professional Responsibility 4.2. Additionally, Your Honor, there's Bar Rule 3.3, candor towards the tribunal. Now, I can't flesh this out without Ms. Love taking the stand. I would love to ask her about it, but in the motion to grant Mr. Copeland immunity, in paragraph 12, I believe it is, they specifically stated that a member of the defense team had contact with Mr. Copeland, and that prompted him to begin to assert that he was going to exercise his Fifth Amendment right.
I would prefer that, since there continue to be allegations back and forth amongst the lawyers, that we specifically get what is actually stated in there instead of, and I know you're not trying to misrepresent anything, you're trying to give it your best recollection, but let's get the actual motion and read the actual words, okay? I've got it somewhere.
Okay, I've got it right here, Your Honor, from Ms. Persifield's email to us.
I've got it. If you've got it at hand, go ahead. But if you don't, I've got it now.
Okay. I'm trying to find out exactly, try to figure out where it was. Okay. Paragraph 11.
Go ahead.
I'm sorry.
Paragraph 11.
Yes. And it says, Kenneth Copeland has been subpoenaed to testify in the above style case. Copeland is the next witness scheduled to testify in this case on June 7, 2024, beginning at 9:00 a.m. On June 4th, 2024, and June 5th, 2024, investigators with the Office of the Fulton County District Attorney coordinated and arranged with Kenneth Copeland to provide Copeland transportation to court on Friday, June 7th, 2024. However, on Thursday, June 6th, 2024, after an encounter with defense team members and members of the Fulton County District Attorney's Office, Copeland stated to an investigator and to an attorney with the Office of the Fulton County District Attorney that Copeland may attempt to plead the Fifth to avoid testifying against members of YSL. I can only speak for myself. I did not have any encounters with Mr. Copeland on June 6th, 2024. I don't believe that any of my colleagues did. I don't believe any members of the defense team did. I don't believe that what's asserted in paragraph 11, to my knowledge, I don't believe it to be the truth. If it is not the truth, and again, I would love to inquire, but Ms. Love would be a witness at that point. Bar Rule 3.3, candor towards the tribunal, would also have been violated. The reason I focus on the violation of these rules is because of the Ford case. And the proposition that we can do something about this besides run to the bar. And that makes sense because it's ultimately if, and I say it did happen, and I say the transcript establishes that it did happen, and you have the transcript, Your Honor. We have in the transcript the state and Judge Glanville both affirming each other that Mr. Copeland can essentially be incarcerated indefinitely until this trial is over, until the trial of the co-defendants is over. That, to me, is coercion. That's intimidation. We have other examples where Mr. Copeland is given what I would say incorrect legal advice about what his exposure is for these allegations and his potential criminal liability. That is coercion. That's trying to convince him to take the stand and plead so that the state can then impeach him with his prior inconsistent statements, presumably. Mr. Copeland, the act of him taking the stand as a result of those ex parte communications has prejudiced, has harmed all of these young men in court here today. So there has to be relief beyond bar issues for them. Your Honor, I'm not going to repeat everything in my motion. You have my motion. I know you've read my motion. But they have a right to a trial. They have due process rights. They have a right to a trial free of prosecutorial misconduct if that misconduct rises to the level of a due process violation. They have an absolute right to a fair trial and due process in front of a fair and impartial trial judge. They also have the right to be present at all critical stages of the proceedings, including, I'm saying, and I think it's fairly clear, that those ex parte communications talking about the witness under the Scudder case that I provided to the court before, that was a critical stage and they were unlawfully excluded. And of course, there's no way we could have acquiesced because we knew nothing about it ourselves. So those are all violations that have harmed these individuals. There has to be a remedy. I believe that the facts are there for you to consider disqualification of district attorneys in this case. And I think Mr. Steele is going to argue that further. But also, I believe that the facts are there under the Wilson case, as well as the State v. Jackson, 306 Georgia 626, Anderson v. State 285 Georgia Appeals 166, and Wilson v. State 233 Georgia Appeals 327. Wilson v. State 233 Georgia Appeals 327.
All right, and those are the three cases that y'all gave me a couple of days ago.
Goading. And the reason I cite to those cases, because it's not often, well, it would be never probably, that a district attorney or prosecutor is going to say, yes, I did this intentionally, I did this to goad. These cases looked at the egregiousness of the violation, the experience of the prosecutors involved. Ms. Love is a chief deputy district attorney in the office, head of the unit
All right.
that deals.
Can I interrupt you for just a minute? So all of this is in your motion, and if and when we get to that point, that would be an appropriate argument, but let's
Okay, well, that
pause
you
it
asked,
for now. I have it.
You asked where we are right now, and that's from my perspective.
Okay.
That's where we are right now.
All right. And I don't mean you can't argue anymore. I just mean
I understand.
the information about their qualifications is in your motion.
Yes, Your Honor.
All right.
Thank you.
Okay. And if Mr. Steele's going to argue as to something else, that's fine. But I had said a little while earlier that with regard to Ms. Love, your proffer about what Mr. Abadi might or might not have to say about Mr. Melnick's representation was not yet relevant. I think it is now relevant, and the proffer has not been accepted. So if you want to present evidence as to that, that would now be appropriate. And I don't mean this very instant, because I'm going to hear from Mr. Steele, but we now know that is an issue. So you can go ahead and get him lined up.
Thank you.
All right, go ahead, Mr. Steele.
Your Honor, I would just like the court to consider the case that was announced to this honorable court by Attorney Shard. I emailed it earlier today to your honorable court's co-worker and all the parties. It's Ford Motor Company versus Young, and it was 322 Georgia Appeal, 348. It's in Division 3. 745 Southeast 2D299 2013 case. And what our second highest court wrote was, and I've given a copy actually to this court. And
Oh yeah, I got the copy. I appreciate it. Thank you.
It's on page 8 of 9 of the copy I've given. It's on the right-hand side, first full paragraph. And it specifically states it in the center. And we have previously held that trial courts may disqualify attorneys for violations of the disciplinary rules. We held that the trial court erred in ruling that because sanctions for violations of disciplinary rules appear to be the exclusive province of the Supreme Court of Georgia, not of the trial court, it lacked authority to determine whether plaintiff's counsel violated 4.2, Rule 4.2 of the Georgia Rules of Professional Conduct, and therefore should be disqualified. We noted that the determination of whether an attorney should be disqualified from representing a client in a judicial proceeding rests in the sound discretion of the trial judge. So I'd just like you to reconsider your order, not disqualifying Ms. Hilton and Ms. Love, and you've inherited a case that has a lot of history, and a lot of it bad. And I put into my motion, I could go over it with the court, and I also attached the YouTube links. It's on July 10th, 2024. I also filed in case the link goes away, I filed on a thumb drive to preserve it. So that's with the clerk's office, and a copy was sent to the prosecution as well. But it started before, but an opening statement. I don't know if you read it. So
I read your motion and I looked at the portions that you were talking about.
Hurtful. It's hurtful. And then as of last week, a new court comes on. It's almost like a breath of fresh air. It's all new. And again, I'm hit with a motion by Ms. Love that was the 4th time the same thing's argued, talking about a duty that is intentionally and knowingly not followed through by me, and I owe it to her. And I saw your email saying, whoever wrote that, you come into court. I understood it.
I don't think Ms. Love did herself any favors with that.
Well, the favors have to end. I'm not trying to, I've never done this before in my history of living in a courtroom, but it's just not appropriate that I can't accept a proffer from a lawyer. I've never said that before. I've never uttered any of those words. So I'll leave it with you. My point is, it doesn't end. There have been no sanctions. It's been ratified almost. And it's from everything. It's just, I put in paragraph 2, just choice examples from my memory. But it is constant. There are great people everywhere in the courts, and they shouldn't be treated like this. So I'm asking you to disqualify because
It's just not. At some point, the message needs to be sent that this is not the state of Georgia and this is not our bar.
All right, thank you. As I understood the gravamen of your motion that you filed since I've been the presiding judge to disqualify Ms. Love and Ms. Hilton, it was because you needed them as a witness, and that was the basis of my ruling. And in Mr. Shart's motion that is under consideration right now is a request, again, to disqualify them. And I know that I previously said, y'all, that's a matter for the bar. And when I was talking about that, I essentially meant the, and I don't want to call it bickering back and forth because I'm not sure it's been back and forth to any large extent, but that kind of thing, the whatever it is that had been talked about before, that's what I was talking about. I will tell you that this court takes Brady violations very seriously. And I mean, everybody ought to, prosecutors ought to, and I am considering that right now. So rest assured that I am aware and have been aware that I have the authority if I choose to remove them.
Thank you.
So, all right. Do y'all want to be heard from the state on this? Or do you want to go ahead and present some testimony to counter the Melnick, that you knowingly contacted Mr. Copeland, knowing he was represented by Mr. Melnick?
Absolutely, Your Honor.
All right.
What we did was ask that our witnesses be summoned, if you will.
Okay.
If the court would just give us
Sure. Why don't we take a convenience break, and can you let a deputy know when you're ready with somebody, and we'll come back out. Thank you.
Thank you.
Appreciate it. Witnesses for the state. Ready? All right, let's get that person on the stand.
Your Honor, state talks out of my body.
All right. I remember one time when I was called as a witness in a case for some very ancillary matter, and we're so used to being the ones examining, we're not used to being the witness. And the direct finish, and I got up to leave, just like all of the lay witnesses who have no clue, and then I felt like an idiot. But, oh well, maybe Mr. Abate won't do that. We'll see. You're coming up to the witness stand.
Like Mr. Melnick, I'm an officer of the court. He's going to swear himself in, but whatever.
All right, let's.
Like Mr. Melnick, I'm an officer of the court. He wasn't sworn in, but yes.
Thank you. Good afternoon, Chief Deputy Abadi. How are you?
Fine, thanks.
Just for the record, would you state where you work and what your position is?
DA's office in Fulton County. I'm the Chief Deputy of the Major Crimes Division.
All right. And February the...
It's ABBATE. And I said Chief Deputy of the Major Crimes Division. Mm-hmm.
February of 2023, where were you working within the DA's office, if anywhere?
Same position.
All right. During that time, do you recall having a conversation with an attorney by the name of John Melnick regarding a person by the name of Kenneth Copeland?
Yeah, it was a conversation on the Zoom call where Judge Whitaker was on the call and heard all the contents of what I'm about to testify to. Yes.
All right. And would you tell the court what the purpose of that Zoom call and that conversation with Mr. Melnick was?
It was related to a bond order or bond conditions for a bond order for his, I think it's 22 SC 182, I think maybe 134 it was his possession of a firearm by a convicted felon and reckless driving, I think is what it was.
Okay. And did you have occasion to look at the bond order and see its contents, or the proposed bond order? Had the state proposed a bond order?
Yes.
Right. And did the state's proposed bond order have any reference to or any conditions that are related to Mr. Copeland's position as a witness in this case, 22 SC 183572?
No, not to my recollection specifically, no.
Did the bond order or the proposed bond order reference co-defendants? Let me ask this. Are you familiar with the co-defendants on, or the defendants on indictment 22 SC 183572?
Some of them, yes. I've tried. I think Khalif Adams was somebody who I was the prosecutor who, when he was convicted of murder.
And the bond order, did it reference some of the defendants on this case?
I think it referenced all of the defendants on the case involving Jeffery Williams.
All right. Did the bond order, well, Your Honor, I'd ask the court to take judicial notice of the bond order, which is in this case
I'll take
already
judicial
filed.
notice of it, but I'm also just going to print it out right now and make it a part of this record, so it'll just be easier.
And I did misspeak and say, in this case, it is actually in Mr. Copeland's 22 SC case.
Yeah, 22 SC 182134.
Thank you. Would you please tell the court the content of the conversation or communication you had with Mr. Melnick regarding Mr. Copeland on that day?
Yes, it was. So it was me, myself, Abigail Potter, who at the time was the trial division lawyer assigned to Judge Whitaker's courtroom. Judge Whitaker and Mr. Melnick, and I believe Ms. Rosser, the case manager who set up the Zoom link, was on the Zoom, and it was just a discussion as it related to the bond conditions for his possession of a firearm by a convicted felon case that was before Judge Whitaker, and the conditions that would be included in it.
Was there any part of that conversation that referenced Mr. Melnick representing Mr. Copeland as a witness in this case?
Yes, specifically. And the reference is that Mr. Melnick was all hot about the fact that I was on the call representing, as a representative pretty much for you as a member of the team for this case, because he specifically said on more than one occasion that I'm not here about that case. I don't represent him on that case. The only case that I have before this judge that I represent Mr. Copeland on is the 22 SC case. He said it over and over again, and he kept making snide remarks as it related to you and the district attorney's office, and eventually me, to which I said, I finally interrupted him. I said, we're done with your used car salesman, stuff. And that's when the judge was kind enough to intervene and say, all right, whatever, we're here just for the 22 SC case. We understand you don't represent him in the YSL case because there's nothing to represent him on, was the gist in my recollection.
And when you're talking about the 22 SC case, are you solely meaning the one Mr. Copeland faced charges on, criminal charges on?
Yes, the one that was before Judge Whitaker that we were there for to, negotiate and agree upon bond conditions for. That I think it's 22 SC 182, I think it's 134, and the charges were possession of a firearm by a convicted felon and I think reckless driving. I think this all happened February 24th of 2023.
Do you know whether that Zoom call was transcribed or whether or not there was a court reporter on that Zoom call?
I'm not sure, but I don't remember seeing, I think it was Miss Evelyn, who was the court reporter back then. I don't recall.
Do you recall how many times Mr. Melnick stated with any degree of emphasis that he did not and was not representing Mr. Copeland in his capacity as a witness in 22 SC 183572?
2 or 3 times, and it was all in relation to the state's request that he be fitted with an ankle monitor. And that was particularly angersome, I guess is the correct word, as it relates to Mr. Melnick's reaction, because that's when he kept saying, this case has nothing to do with that case. I have nothing to do with that case. I don't see why he has to have an ankle monitor.
Are you familiar with what it is that the state was trying to secure with the ankle monitor?
His location at all times, I suppose.
And are you familiar with Did you speak with Mr. Melnick at any other time regarding his representation of Mr. Copeland as a witness in this case?
No, I try to avoid him as much as possible.
Has he ever in life represented to you that he represents Kenneth Copeland as a witness in this case?
No, it was the exact opposite in front of the exact same judge that we're sitting before today.
And showing what our market states is it too, Your Honor, I don't know if the court had already.
Here you go. Here's the bond order.
Showing you State's Exhibit 2, which I'll mark, which is a copy of the filed bond order. Is that the bond order that you spoke with Mr. Melnick about on the date that you're speaking about now? Or is there?
So this would be the bond order that came from the conversation we had in February, I think February 23rd, excuse me, February 24th of 2023. This is this is stamped for March 3rd. So there would have, the whole reason for the Zoom was to negotiate and come to some sort of agreed upon set of bond conditions as it related to Mr. Copeland and being released on bond for the 22 SC 182134. That was right. So this would have been the product of that conversation.
Okay, thank you. All right, that's all that I have with this witness, Your Honor, for right now.
All right. Any questions by any of the defense attorneys for this witness? Nope. Ms. Weinstein, Mr. Matthews?
No, Your Honor.
Mr. Harvey, who I can't really see over there in the corner. Is he even there? Is Mr. Harvey over there? Anybody for Mr. Harvey's client? Any questions? Okay, great. Thank you for your time. You may step down. All right, call your next witness.
State calls Attorney Peter Herzog.
Okay. It doesn't matter to me. I mean, do you want him sworn or do you want him to testify in his place?
I'll have him sworn in.
All right. Yes, please swear him.
I raise it right hand. Swear I first testimony you. You tell the truth, the whole truth, nothing but the truth.
I do.
Have a seat. First,
Peter, P-E-T-E-R, Herzog, H-E-R-T-Z-O-G.
TC.
T-Z-O-G.
Mr. Herzog.
Good afternoon.
Would you please, just for the record, state for the court where it is that you work and what position you hold there?
So I'm a senior assistant district attorney in the anti-corruption unit of the Fulton County District Attorney's Office.
How long have you worked in the anti-corruption unit?
Since I started in the office, about a year. I think I started March of 2023.
Did you say March? And I just need to speak up a little bit louder. March 2023.
Yeah, I think it was March. I've been here about a year and a half.
Okay. Have you ever worked in any unit besides the anti-corruption unit?
I did a short stint where I screen cases and then I cover a court part for a complex, but I've always remained in anti-corruption.
As an attorney with the anti-corruption unit, have you ever had an occasion to speak with Mr. John Melnick about a person by the name of Kenneth Pope?
Yes, I believe so.
At any time during those conversations, did you ever, in any way, seek any information regarding Mr. Melnick's representation of Kenneth Copeland as a witness in the case 22 SC 183572?
No.
Did you ever, in any of those conversations, have any occasion to talk with Mr. Melnick about his representation of Kenneth Copeland as a witness in any YSL related case?
No.
Did you ever, during your conversations with Mr. Melnick, reference either myself or Deputy District Attorney Simone Hilton?
No, not to my recollection. No.
Have you ever been asked by either of us or anyone prosecuting the YSL case to reach out to Mr. Melnick?
No, absolutely not.
Is this the longest you and I have ever even talked?
I believe so. I think I ran into you once in the hallway and said hello. Other than that, I don't think we've had much contact.
Did the matter that you spoke with Mr. Melnick about have anything to do, in any tangential, direct, indirect, any way, have anything to do with 22 SC 183572 or the criminal indictment that preceded it?
Absolutely not. No.
Was the case that you spoke with Mr. Melnick about a case that was in your unit?
Yes, ma'am.
Were you ever asked by anybody within the DA's office to have any communication with Mr. Melnick regarding his representation of Kenneth Copeland as a witness in this case?
No, ma'am.
Did Mr. Melnick ever just tell you, hey, I'm representing Kenneth Copeland as a witness in the YSL case?
No, not to my recollection.
Do you recall sending Mr. Melnick an email back in March of 2023?
March of 2023. I don't recall.
Your Honor, I'm not certain exactly where the evidence.
I'm sure it's somewhere with the court reporter. I'm going to show you what has already been admitted as Defendant Williams number 4, Your Honor. And I'm going to show you ask you to take a look at the bottom portion of Defendant Williams number 4. And ask you if you recognize that time frame as a time frame that you reached out to Mr. Melnick.
I did reach out to Mr. Melnick. It could have potentially been around that time frame. If you'd like, I can go into more detail.
Yes, please.
So we were investigating, as part of anti-corruption, we were investigating.
Without getting into the details of any anti-corruption case
Okay.
at all.
There was an allegation made that involved Mr. Copeland. At the time, I was relatively new to the office. I'm not from here. I'm from New York. I spent years practicing up there. So I know nothing about what's going on down here in relation to this case. I reached out to Mr. Melnick to see, as per our usual in our unit, to speak with every witness. And I believe I asked him if Mr. Copeland wanted to talk about that specific matter. And I don't believe we ever followed up on it.
Was Mr. Copeland in jail at the time that you reached out to Mr. Melnick?
I believe so.
So was Mr. When you reached out to Mr. Melnick, where and why did you seek to go through Mr. Melnick to get to Mr. Copeland?
Because, if I remember correctly, he represented Mr. Copeland in that other matter.
To your knowledge, had that other matter been resolved?
At the time, I'm not sure if it was resolved at that time. I don't believe so. I think that's why I went through Mr. Melnick, I believe.
Outside of the anti-corruption matter, did you speak with Mr. Melnick regarding anything else related to Mr. Copeland?
No, ma'am.
That's all I have.
All right. Any defense examination of this witness?
You know, I did a thing, I wrote a check mark, and I'm gonna have to get that off the report.
Okay, probably have some white on it, if that would work. Is that okay with everybody if on states 4, Ms. Love White felt the check mark she inadvertently wrote on states 4, which is why I don't like to ever handle the evidence, because I'm constantly taking notes and then I end up writing on the evidence.
And Mr. Phillips, Williams exhibit.
Is that okay? All right. Thank you.
With the court's permission, I'll do that after Mr. Sharp has had an opportunity.
Go ahead, Mr. Sharp.
Good afternoon.
Good afternoon.
So, from what I understand, March 2023, you are working for the DA's office in anti-corruption.
Correct.
Okay, and you are building up a case?
Yes. I'm investigating a case, not building up a case. I'm investigating a case.
And is Mr. Copeland the target of this case?
No.
Okay, so he is a witness.
Yes, he would have been a witness.
He's a fact witness, I assume?
Objection, Your Honor, to the relevance of what type of witness Mr. Copeland.
Sustained.
Okay. What kind of case was this?
Objection as to the
Well, can we just leave that it's an anti-corruption type case?
I ask, was Mr. Copeland a alleged victim?
No.
So he's a witness.
Well, it's...
Your Honor.
Yes. Do we need a bench conference? Okay. the earphones work right now. So what I'm wondering is if y'all would be comfortable with Mr. Sharp relaying the substance of the bench conference, or if each of you wants to try to come up and gather around, or...
And Your Honor, since we cannot have, since we don't have the ability to let it be heard, I'd ask that the court ask whether each defendant waives their presence at the bench conference.
So do the attorneys want to come up, or? Okay, so I know the defendants normally are able to hear what's going on. I'm sorry we're having technical difficulties. Apparently you need to put these things on their charger pretty frequently in order for them to work. So I'll know that for the next time. One of your attorneys is going to come up and listen to what the substance of the bench conference is, and then I am directing them to return to the tables and let you all know what we talked about. I want to find out whether that's okay with each of you defendants. And also, I am happy if you're not satisfied with what the attorney has told you about it, to then you can let me know and I can say, well, here's my take on what happened. Okay. So, Mr. Kendrick, are you okay with Mr. Weinstein just coming up and then telling you what we talked about? All right. How about you, Mr. Huey? All right. Thank you. Mr. Williams. Okay. Who else do we have? Mr. Stillwell, are you okay with that? All right. And then Mr. Ryan, you okay with that? All right. Thank you. Appreciate it. So y'all can't even get it.
Yes, Your Honor.
And do any of the defendants have any questions about it that they want to ask me? Okay. And did you talk to your client about it?
I will.
Do you? Okay. All right, go ahead.
Attorney Herzog,
Spin your mic towards you.
the anti-corruption case that you were working on in March 2023, is that still an active investigation?
No, it is not an active investigation. It was and the investigation was wholly unrelated to YSL.
Okay, and is there a pending case involving that investigation that resulted from that investigation?
A pending criminal case?
Yes.
No.
Now, at the time you sent this email, you wanted to speak with Mr. Copeland, correct? About the matters you were working on?
Yes.
Okay. And you have the ability as a district attorney, you said that your understanding is he was in jail, correct?
I believe so.
Okay, and you have the ability to go to the jail at 901 Rice Street, correct?
Yes, I have the ability to go to the jail.
Okay, and as a district attorney, you have the ability to bring an investigator with you and interview a witness there, correct?
I wouldn't represent someone I wouldn't speak with someone that was represented by counsel.
Okay.
On any case or was recently represented by counsel.
Okay, so the reason that you called Mr. Melnick is because you would not speak ethically. Your code of ethics, you would not want to speak to someone who's represented, correct?
It's all of our code of ethics.
Correct. And you also would not want to speak to someone who was represented recently. Is that what you said?
I would reach out to the defense attorney prior to that, yes.
And that's what you did in this case. You reached out to Mr. Melnick, correct?
Regarding our investigation, in the
I
limited
understand.
scope to our investigation.
Yeah, I understand. You were not involved in the YSL investigation, correct?
Correct.
Okay. But as part of your investigation, you reached out to Mr. Melnick in an effort to speak to his client, Mr. Copeland, correct?
Yes, I believe so.
I have no further questions. Thank you.
Does anybody else have questions for Mr. Herzog? All right. No?
Inquiry for the court.
Sure.
I don't understand enough about it, and I understand that the ruling is maybe I shouldn't know about it. With the court, Mr. Williams has no objection. And if you do, please correct me. Would the court be able to find out whether this has any Brady implications from Mr. Copeland, either under Giglio getting a deal or he did not get prosecuted because he was involved, but he was being used as a witness, and I don't have that information.
Sure, I don't either, but that's valid. Let's find that out. So you can ask that question. You don't have any objection to that question, do you, from the state? Okay.
Hello.
Mr. Still.
How are you?
Good, how are you?
I'll let you know. Brady evidence, you feel comfortable talking about Brady evidence, what is required by Brady and its progeny?
Is the question whether I feel comfortable?
Yeah. Do you understand Brady and its progeny, what it includes?
Yes.
Okay. And I didn't mean that to be insulting at all. Just, some people have different definitions of something. Dealing with Mr. Copeland, only Mr. Copeland, was there any type, no matter how non-promising, was there any type of agreement, promise, benefit to him, whether that's reduced charges, no charges, he's cooperating, he's a CI or whatever you want to call it, anything to do with that?
Absolutely not. I have no information regarding the YSL case or any investigation of the YSL case. I reached out solely related to a wholly unrelated matter.
Okay. And I'm running it besides what you call the YSL case. I'm saying, was Mr. Copeland given any benefit? Forget about this indictment before the Honorable Judge Whitaker. Was he given any benefit on any matter, including the matter you were investigating?
Not to my knowledge, no.
Okay. All right. Thank you, Your Honor.
Okay. All right. Anybody else? Mr. Williams? Okay. Anybody? All right. Any redirect by the state? No, Your Honor. All right. Thank you. You may step down.
Thank you, Your Honor.
And did you have one other witness?
Yes.
Are they ready?
Can the court allow Mr. Atkins to go outside and check?
Sure. While we're waiting on finding that out, y'all were, well, I guess it was Mr. Atkins that was going to do it, so never mind. I'll wait on that one, trying to see what else we can get done while we're waiting. Nothing. Huh?
There was one matter, I guess, as it relates to Mr. Copeland, that I would ask that the court take additional notice of, since we're all on here.
What's that?
The date that his criminal matter that we were just introducing testimony about was resolved. There should be within the 22 SC 134, I believe, case in Odyssey, a disposition for those criminal charges. I would ask the court just to take judicial notice of that date. Okay.
All right, so it appears that the plea was entered on June 28th, 2023, and the disposition was filed on June 29th, 2023, and I'll take judicial notice of that. All right, what do we know, Mr. Atkins?
So Ms. Potter is 30 minutes away. I'm not going to ask the court to wait on.
Okay.
I'm
Okay.
sorry, he said 40 minutes. He corrected.
Okay.
And so rather than have the court wait on that,
We're going to do that tomorrow?
I can, yes, I can do that.
All right.
And Your Honor, the other thing that I was looking at was I'm obtaining a certificate of service for Mr. Copeland that I believe was filed. I think he was served most recently in May of 2024. And if the court would indulge me one moment, I was just trying to determine who it was that served him, since the subject is state's actions regarding a witness, Mr. Copeland. And I would also argue to the court that there is not standing to complain of the interactions between state prosecutors and their witnesses in this case, and there's not standing to complain of what happened as it relates to Kenneth Copeland in the in-chambers hearing. But to the on June 10th, in terms of King and its progeny, and what the transcript reflects, and the court has heard testimony reflecting.
All right. Well, their claim is a right to be present, and they have standing to make that claim. Whether I make a determination that they did have a right to be present or didn't is yet to be determined, but they can certainly make the claim. Was there, with regard to them, are there not being standing to complain about whether the state communicated with Mr. Copeland when, according to the defense, the state knew him to be represented. I understand the assertion in that regard to be that the prosecution has violated a bar rule and that they've also violated other bar rules over the course of this case, and that I should take that into consideration in determining whether and what remedy to fashion. Do I have that about right? I'm getting nodding yeses. Okay. So yeah, they can assert that to the court.
Okay. And Your Honor, as I obtained for the court that those final two pieces of information.
Okay.
I'd ask for the court's brief indulgence while I give the certificate of service and the date that he was served.
Okay. I'm not even sure which one you're talking about, but sure, if it's relevant, I will unseal it. Can you let me know which one it is?
It was a certificate of service and it was filed on. Okay, that's what we're getting today.
Okay. It's and that's in which case? This
22.
YSL case?
Yes.
Okay. So I actually, once you let me know what it is, I actually, because I'm the court and I can, kept a copy of what is in each of the sealed filings once I reviewed it, so that in case we needed to see something again, I didn't have to do another order unsealing and resealing. So those are in an envelope in my litigation manager's office. And when you let me know what it is I'm looking for, I'll just pull it out of there.
There is a certificate of service for Kenneth Copeland that should have been reflective of a subpoena that was served on him, I think, in May of 2024.
Okay. Without
the exact date, I don't want to, I think maybe May 31st.
Okay.
That sounds about right. May 31st of 2024.
Sure. And maybe Ms. Persfield, you already are anticipating my need and sending an email to Ms. Rosser to see if she can pull that. Thank you. All right. And then with regard to Ms. Potter, is she going to be available in the morning, or does she want to Zoom? I don't care if we take her testimony by Zoom if nobody else does. Okay. I don't even know if she's available, but that's an option as well.
Thank you, Judge. That would actually work. I'm going to.
All right. Would that be okay? If I don't know if everybody's familiar with Ms. Potter, but I don't know if is she still with the DA's office?
She is. She's
okay.
Outside.
She's a prosecutor with the DA's office who used to be in my courtroom and who was the prosecutor for the case that Mr. Meldick handled on the other side of. Would everybody be okay on the defense side with us taking her testimony by Zoom here in court? If anybody has an objection, please voice it orally now. Okay. All right, so that'll work. If you can line her up for that, and I think you already have the Zoom link, we can do that.
Thank you.
All right. And as Ms. Love's doing that, Mr. Adkins and whomever from this side of the courtroom was going to work on the maybe one or two issues with Mr. Copeland's jail calls over the weekend. Did y'all get an opportunity to do that and reach any kind of resolution?
Your Honor, I have not spoken with any defense counsel in relation to those jail calls.
Okay. Wasn't that your task?
Your Honor, I will speak with Mr. Shard.
Okay. I can't remember who said they were going to do that, but I don't know. Y'all had told me at the end of Friday, before we had all of our more explosive motions put before the court that on the jail calls that might or might not come in with Mr. Copeland's testimony, y'all had maybe 2 items that you thought you could work out everything, and there were 2 items that were still kind of in dispute?
That may have been Ms. Hilton.
It might have been. I don't know.
Just to get him.
I was out a little bit on Friday, but did Mr. Steele not deal with the jail calls at the end of the day on Friday?
I mean, so what we ended up doing was saying, oh, we may be able to just come to agreement on everything. So give us a little minute over the weekend and we'll get back to you. Anyway, apparently nobody did it, but y'all do that
Yes, Your Honor.
tonight, if possible.
Yes, Your Honor.
Your Honor, may I be allowed to step outside the courtroom for a brief 5 or 7 minutes?
To line up Ms. Potter?
To line up Ms. Potter and to speak with another member of our office.
Okay, so we will take another break and be back whenever you let a deputy know that you're ready, okay? Which hopefully won't be more than 10 minutes. All right. That's everybody all right?
Thank you, Judge. The state is asking if the court will allow us an opportunity to respond to the Ford Motor Company case that we provided today, and in making our final argument, and to allow us, if we decide the need, to call ADA Potter. The main thing that I wanted to get out was regarding when Mr. Copeland pled, and I haven't had an opportunity to talk to her about that. I think she was the one that represented the state in that plea.
Yeah, she was, but I mean, I told you that he pled on June 28th of 2023.
Right. When I first started looking at Abigail Potter and had the 3 names.
Oh, okay. So you may not need her after all, then that's fine. Yeah, if that's all you needed her for, it's in the court record.
Okay.
And I have taken judicial notice of it. And then a response to the Ford case, I mean, with regard to whether that's the law or not, or whether that's an appropriate
I have not
sanction. Yeah, yeah, sure. You haven't had a chance to take a look at it, sure. Is that what you're saying?
Yes.
Yes, that's fine. You can make whatever response, if any, you want to in the morning.
And thank you. So that's it.
Okay.
Outside of Ms. Potter, I don't think that we would have any other persons to present. But if we did, we would have them here and ready to go first thing. I just wanted to review all of our notes and make certain that every issue that was raised here today is addressed properly.
That's fine.
Thank you.
And Ms. Rosser's looking for that certificate of service of the subpoena. And
I know that you keep copies, so I can get one of those too.
I think that I've got the certificate of service of a subpoena that you are referencing, because it has that on May 31st, Investigator Long actually served Mr. Copeland, and I'll let you look at it, but it looks like it actually is also attached as a and I don't know if it was or not, but it at least references that the order that Judge Glanville enters on the 7th that is pursuant to 24-5-507 that gives him immunity maybe attaches that subpoena, but I don't know. Anyway, if you want to come take a look and see whether that's what you mean? And if so, we can make a copy of it and you can do whatever you want with it from there.
Okay.
Is that it?
It is. It is. It's attached to the, as the court said, it's attached to the motion to, well, the order granting the state's motion to compel.
All right. And so it's already, I would think, then in the record.
Yes. Yes.
All right. And so what's their argument you wanted to make about that? Or just
that, and I can reserve the rest of it for tomorrow, but just that he was served, Mr. Copeland was served on May 31st, and I think that's well a week before he was ever called to testify or anyone was informed that he would be the next person up. And we did not, I'll make argument at the appropriate time.
all right. Okay, so tomorrow, in addition to wrapping up whatever final evidence and argument there might be as to either of those issues, what I would like, I think y'all now have, if not every bit of Mr. Copeland's prior testimony, almost every bit of it, and Ms. Weaver's been pretty fast at turning it around. And at this point, it may be best to redo the entirety of Mr. Copeland's testimony, including bringing him back in and asking him whether he wants to testify. And I'll hear from everybody on what we might need to advise him of, if anything he's been, or re-advise him of, or correctly advise him of, and then just maybe start from scratch with him. If there are things that everybody can agree, I just don't know whether we know what he's going to do or how he's going to testify. So I don't know if it's productive to continue to look and see whether there are things y'all can agree on. But if there are things that everybody can agree on and we can just say, okay, you know, these 5 things take as, you know, something he said and the rest of it redo, or whether we just want to start 100% from scratch. As I understand it, nobody had played the June 10th, 2015 interview from him yet anyway, right?
That's correct.
Okay, and that's the only one where he inculpates any of these defendants, right?
No.
No, that's not right. That in the Donovan Thomas murder is what I mean.
Oh. That's the first one, yeah.
Okay. All right.
Directly in the way that he did on
Okay. Yes. Okay. All right. But we need to make some progress into the, I mean, I am still considering and working through Mr. Shart's motion, and then we'll get to Mr. Weinstein's motion for mistrial. Both of them are motions for mistrial. But assuming for the purposes of getting things done that those are not ultimately granted, then we need to pick back up with this trial. Obviously, if they're granted, then that's a whole other ballgame. But I want us to make progress in the meantime. So tomorrow, I would like for our focus to be on how to handle Mr. Copeland and his testimony or potential testimony once we have the jury back, whether there's any agreement as to anything, proposed jury instruction as to if we're disregarding any or all of it, what that should say, whether we need to take notes, all of that kind of like the details we actually need to think through. I want y'all working on that tonight so that we can make progress with that tomorrow. And, you know, there are a lot of things up in the air in this case. And I am going to once again say to everybody that there's a lot of risk for everybody. There's a lot on the line for everybody, both sides of this case. And I know not everybody has necessarily the most fruitful relationship with each other across the aisle right now. But I know, Mr. Steele, you said that you do still have a good relationship with the district attorney herself, who certainly authorized to talk about each and every case because they're all her cases ultimately. But, you know, y'all need to be thinking about all of the potential ways to handle and move forward in this case. And I encourage y'all to be doing that because who knows what it's going to be otherwise, okay?
And Your Honor, we did get last night, speaking of things that we can deal with.
Yeah.
We got last night from Mr. Sharp, and he can correct me if I'm wrong, I believe about 76 proposed redactions from the proffer of one of our witnesses that we discussed on Friday, Mr. Zachary.
Okay.
At some point, I know that the court is going to have us to address those. So, and I believe that Mr. Sharp, he can again correct me if I'm wrong, said that he could go through that was from the August 2017 interview, a proffer from Mr. Zachary, and there's an earlier one that I think he said he's going to go through and okay. He said he's going to go through another one.
Okay.
And so if he sends us those, that's another thing that we need to work out.
Perfect. And so y'all go ahead and tackle the first 76, see if there are things that you can agree on so that we can have an efficient day like we did on Friday where we sort out so that everybody knows here's what can and cannot come in potentially with regard to this witness. And he's coming up pretty soon. And if Mr. Copeland makes a decision different than his last decision, we may be getting to Mr. Zachary sooner than we think.
And if that is the case, then the state would have a motion for the court, similar to the one prior, with respect to Mr. Copeland.
You're going to have to give me a hint as to what you mean by that.
So, Your Honor, just now, Your Honor referenced if Mr. Copeland chooses to do something different than what he chose to do last time, with respect to testifying. I'm assuming the court needs to plead the fifth again. I don't know.
Well, I mean, I'm not undoing the immunity order. The immunity order stands. Unless y'all got some, I mean.
That's what I understand.
Okay. All right. Well, I mean, I guess we can. I don't at this point see a need to undo and potentially redo an immunity order. I know that there is the argument about how paragraph 11 might contain a misrepresentation as to whether there was an encounter. I mean, the way I read it and what it says is there was an encounter with representatives of the DA's office and people from the defense team. After that, Mr. Copeland told somebody he might plead the fifth. Now, I don't know whether from that it means Mr. Copeland was even a part of that encounter or if that's just given me some kind of a timeline about one thing happened and then another thing happened. But the import of that to the predecessor judge, and to any judge considering does immunity need to be granted and is immunity in the public interest here, is not what triggered it. It's this witness, who the state thought was going to be testifying voluntarily under subpoena or not, now intends to take the fifth. The only way we can get their testimony, which we believe we need, is to compel it. Will you compel their testimony? That's the import of it to me, not what led up to it, because there's no allegation of coercion or dirty dealing or anything like that, if it even means that Mr. Copeland was involved in any of that. So I don't believe that the immunity order needs to be redone. If somebody else thinks differently, y'all let me know that right now. Silence. Mr. Steele.
I don't believe anything before Mr. Weinstein filed the first motion to recuse. I'm not challenging anything before that.
Okay.
But I do want to hold, there was a lot of exculpatory information before the recusal motion was filed, so I don't want to wipe out Mr. Copeland's testimony on the 10th,
All right.
11th, or part of the time.
All right, which is why I need y'all to get together on it, and let's tackle that tomorrow. The nitty-gritty of it, okay? All right, so that means y'all have to do that tonight if you haven't already done it. All right, anything else before we break for the evening? No. One more thing. All right, so it's my understanding that other than the transcript of June 12th, everybody should at this point have all of the testimony of Mr. Copeland, and the transcript from the 12th should be forthcoming within hours. And, you know, Miss Weaver was working at like midnight last night. So as soon as she gets it, she'll either forward it to Ms. Percival, who forwarded it to you, or she'll forward it directly. So y'all should have that very shortly. All right, anything else before I bid y'all adieu for the day?
May I inquire if it's appropriate? Is the court's plan to bring the jurors back in on Wednesday? Is that still the plan?
I don't know, because we got things done today, but we didn't get any evidentiary, make any evidentiary progress today. So I don't know. It's less likely now than it was on Friday. And I'll just let y'all know right now that I have an appointment that was set up well before I had any involvement in this case for Friday morning. So I am not available this Friday morning, regardless, this coming Friday morning. And I'm not gonna, I don't know. Let's just see how tomorrow goes. I think we'll have a much better idea tomorrow, whether it's Wednesday for 2 days, which I don't love, or whether it's just next Monday, and let's actually make lots and lots of progress in the next few days, and then buckle down with a trial on Monday if it turns out being that. But I'll, remind me tomorrow to think about that again. All right. We're adjourned for the day.